I never imagined that a Tuesday morning coffee on my back porch would turn into a 3-year legal nightmare. But watching a construction crew tear into my grandfather's land while I was staying there for the summer changed everything about my life. My name is James Ellsworth, and I had just graduated from law school at the University of Virginia when my mother asked me to spend the summer at my grandfather's property in Charlottesville. Grandpa William had passed away 6 months earlier, leaving behind a beautiful 8-acre estate that had been in our family since 1947. The property was tucked away on the outskirts of the city, surrounded by old oak trees and rolling hills that made you forget you were only 20 minutes from downtown. My mother and her siblings were still sorting through probate, and someone needed to keep an eye on the place. I figured it would be a quiet summer to study for the bar exam and decompress after 3 brutal years of contracts, torts, and civil procedure. I arrived on a Sunday in early June, driving up the long gravel driveway that wound through the property. The main house was a charming 2-story colonial with white siding and black shutters, exactly as I remembered from childhood visits. Grandpa had maintained it beautifully, and the garden still bloomed with his prized roses. I spent the first few days settling in, exploring the property boundaries and establishing a routine. Every morning, I would make coffee, sit on the back porch, and review my bar prep materials while enjoying the peaceful view of the back acreage. That Tuesday started like any other. I woke up at 7, made a pot of strong coffee, and carried my study materials out to the porch. The June air was already warm, promising another hot Virginia summer day. I was deep into a constitutional law hypo when I heard the rumble of heavy machinery in the distance. At first, I assumed it was coming from one of the neighboring properties, but the sound grew louder and closer. I set down my notes and walked around to the side of the house, following the noise. What I saw made my stomach drop. 3 large vehicles, including a backhoe and a dump truck, were rolling across the back section of the property, about 200 yards from the main house. A group of men in hard hats and reflective vests were setting up what looked like surveying equipment. I broke into a run across the lawn, my coffee forgotten on the porch. As I got closer, I could see that they had already begun marking out a large rectangular area with stakes and bright orange string. The backhoe was positioned to start digging. "Hey!" I shouted, waving my arms. "What are you doing? This is private property." A man in a yellow hard hat turned toward me, clipboard in hand. He was middle-aged with a weathered face and seemed completely unfazed by my arrival. "We're with Morrison Construction. We have authorization to build tennis courts here." "Tennis courts?" I stared at him in disbelief. "Authorization from who? I'm the property caretaker and nobody authorized anything." He flipped through the papers on his clipboard. "Says here we're working for the Magnolia Ridge Homeowners Association. They've got all the permits and approvals. We're just doing the job." Magnolia Ridge. The name sounded vaguely familiar. It was a housing development that had been built about 5 years ago on the other side of the main road, about half a mile away. But what did they have to do with my grandfather's property? "This land has nothing to do with that HOA. You need to stop right now." The construction foreman sighed, clearly annoyed. "Look, buddy, I don't know what to tell you. We've got our work orders, we've got permits from the county, and we've been paid to do a job. If you've got a problem, take it up with the HOA." "I'm taking it up with you," I said firmly, putting every ounce of authority I could muster into my voice. "This is the William Ellsworth estate, and it has never been part of any homeowners association. You're trespassing, and if you don't stop immediately, I'm calling the police." That got his attention. He held up a hand to his crew, who had been watching our exchange with interest. "All right, hold on. Let me make a call. He walked a few yards away and pulled out his cell phone. I could see him having an animated conversation with someone, gesturing at the property and occasionally glancing back at me. Meanwhile, I pulled out my own phone and called my mother. "James, is everything okay?" She sounded worried. I rarely called her before noon. "Mom, there's a construction crew on Grandpa's property trying to build tennis courts. They say they're working for some HOA called Magnolia Ridge. Do you know anything about this, tennis courts?" "No, absolutely not. We never authorized any construction." "James, you need to stop them right now." "I'm trying, but they claim they have permits. I might need to call the police." "Do it. And call Uncle Robert, too. He's been handling most of the estate paperwork. This is insane." I hung up and immediately dialed 911. The dispatcher was professional and calm, taking down the details and promising to send an officer to the property. While I waited, the construction foreman walked back over, his expression grim. "My supervisor says we're moving forward." The HOA president assured him everything is legal and proper. "If you've got complaints, here's her number." He held out a business card. I took it, reading the name printed in elegant script: Brenda Patterson, President, Magnolia Ridge HOA. There was a phone number and an email address below. "I've called the police," I told him flatly. "I suggest you and your crew wait right here until they arrive." His jaw tightened. "We're on a schedule and we're getting paid by the day. I can't afford to sit around waiting for cops to sort out a property dispute." "Then I guess you'll have to explain to them why you were trespassing and damaging private property." For the next 20 minutes, we stood in an uncomfortable standoff. The construction crew milled around their vehicles, some of them sitting on the bumpers and drinking water, others checking their phones. I remained positioned between them and the marked-out area, my arms crossed, trying to look more confident than I felt. My heart was racing, and my mind was already running through property law statutes and trespass doctrines from my classes. Finally, a Charlottesville police cruiser rolled up the driveway, followed by a second one. 2 officers got out, both looking curious but professional. One was an older black man with sergeant stripes, the other a younger white woman with her hair pulled back in a tight bun. "I'm Sergeant Williams," the older officer said. "Someone want to tell me what's going on here?" I stepped forward. "I'm James Ellsworth. My grandfather owned this property, and I'm currently staying here as caretaker while the estate is in probate. This morning, this construction crew showed up and started preparing to build tennis courts. They claim they have authorization from a homeowners association, but this property has never been part of any HOA. They're trespassing." Sergeant Williams turned to the foreman. "And you are Dave Morrison Construction. We were hired by the Magnolia Ridge HOA to build tennis courts at this location. We have all the proper permits and work orders." He handed over his clipboard. The sergeant studied the papers carefully, his expression neutral. "These permits list this address, and they appear to be signed by the county planning office. But Mr. Ellsworth says this property isn't part of the HOA. Do you have any documentation showing that it is?" Morrison looked uncomfortable. "That's not my department. The HOA hired us and told us where to build. I assumed they had the legal right." "Assumption isn't good enough when we're talking about private property," Williams said. He turned back to me. "Do you have documentation proving ownership? I can get it. My uncle is the executor of the estate. But I can tell you for certain that my grandfather never joined any HOA. He bought this land in 1947, decades before that development was even built." The female officer, whose name tag read Chen, had been walking around the perimeter, looking at the survey stakes. "Sergeant, this area is pretty far from the road. If they were just using a GPS coordinate, they might not have realized they were crossing property lines. Williams nodded slowly. "Mr. Morrison, I'm going to need you and your crew to cease all work here until this gets sorted out. If you proceed, you could be charged with trespassing and property damage." Morrison looked like he wanted to argue but thought better of it. "Fine, but I'm billing the HOA for the lost time and I'm noting in my report that we were stopped by police." He turned to his crew. "Pack it up, boys. We're done for today." As the construction vehicles rumbled away, I felt a wave of relief wash over me. But Sergeant Williams wasn't finished. "Mr. Ellsworth, I suggest you contact the HOA as soon as possible and get this straightened out. If they have permits from the county, there might be some confusion in the records. You'll want to bring proof of ownership and get everything documented." "I will. Thank you for coming out." After the police left, I went back inside and immediately called my Uncle Robert. He was furious when I explained what had happened, and promised to dig through all the property records and estate documents. Then I sat on the couch, staring at the business card the foreman had given me, and debated whether to call this Brenda Patterson right away or wait until I had more information. I decided to call. If this was just a simple mistake, maybe we could clear it up with a conversation. The phone rang 3 times before a woman's voice answered, dripping with the kind of syrupy sweetness that immediately put me on edge. "Brenda Patterson speaking." "Miss Patterson, my name is James Ellsworth. I'm calling about the William Ellsworth property on Old Creek Road. Your construction crew was just here trying to build tennis courts." "Oh yes, the tennis courts." Her voice brightened. "Isn't it exciting? The community has been asking for better recreational facilities for years. We finally secured the funding and permits." "Madam, I need to inform you that you're building on private property. The Ellsworth estate is not part of Magnolia Ridge and never has been." There was a pause. When she spoke again, her tone had shifted, becoming sharper. "I'm not sure where you're getting your information, but I have documentation right here showing that the property in question is designated as common area land for our HOA. The tennis courts are a community improvement project, fully approved by the board and the county." "That's impossible. My grandfather owned that land for over 70 years. It's currently in probate as part of his estate." "Well, I don't know anything about that," Brenda said dismissively. "But I do know that we have every legal right to proceed with our project. In fact, if you interfered with our construction crew, you could be the one in trouble." I felt my jaw clench. "Miss Patterson, the police were here. They told your crew to stop. This is a matter of property ownership, and I can assure you that the Ellsworth estate is not HOA land." "We'll see about that. I'll be contacting our attorney and having him review the matter. But I expect this project to continue as planned. The community is counting on these tennis courts. The project is not continuing on private property. If your crew comes back, I'll have them arrested for trespassing." "Young man, I don't appreciate your tone. I am the president of this HOA, and I have a responsibility to our homeowners. We've done everything by the book. Perhaps your family should have kept better track of their property boundaries." The condescension in her voice made my blood boil, but I forced myself to stay calm. "You'll be hearing from our attorney. Do not send anyone else onto this property." I hung up before she could respond. My hands were shaking with anger and adrenaline. This wasn't a simple mistake. Brenda Patterson genuinely believed she had the right to build on my grandfather's land, and she wasn't backing down. Over the next few days, I threw myself into researching everything I could about property law, HOA, and adverse possession. Uncle Robert sent me copies of all the estate documents, including the original deed from 1947. Tax records showing continuous payment by the Ellsworth family. and a recent survey that had been done 2 years ago when Grandpa was updating his will. Everything confirmed what I already knew. The property was entirely owned by the estate, and there was no connection to Magnolia Ridge whatsoever. But when Uncle Robert contacted the county planning office, things got more complicated. According to their records, the parcel where the HOA wanted to build the tennis courts was indeed listed as common area land associated with Magnolia Ridge. Someone had filed paperwork 5 years ago, when the development was first built, designating several parcels as HOA property. One of those parcels matched the description of the back section of Grandpa's land. "It's a clerical error," Uncle Robert said over the phone. "It has to be. But the problem is, now it's in the official county records. We're going to need to get this corrected, and that might require going to court." "Can't we just show them the deed and the survey? That should prove ownership." In a rational world, yes, but bureaucracies don't always work rationally, and if the HOA has been paying taxes on that parcel as common area, things get even messier. Have they been paying taxes on it? I'm looking into that. Give me a few more days to pull all the records. In the meantime, I kept a close watch on the property. I walked the boundaries every morning and evening, making sure no one was trying to sneak onto the land. I also started researching Brenda Patterson and the Magnolia Ridge HOA. What I found was not encouraging. Magnolia Ridge was one of those suburban developments with strict rules about everything from mailbox colors to the types of flowers you could plant. The HOA had a reputation for aggressive enforcement, with multiple news articles about disputes with homeowners over minor violations. Brenda Patterson had been president for 3 years and seemed to relish the power. In one article, she was quoted as saying, "Rules exist for a reason. If people don't like them, they shouldn't have bought in a planned community." I also found several complaints filed with the Better Business Bureau and the State Consumer Protection Office. Homeowners accused the HOA of arbitrary fines, lack of transparency in financial matters, and bullying tactics. One family had even sued after the HOA placed a lien on their house over a dispute about fence height. This was not going to be easy. A week after the construction crew had been turned away, I received a certified letter. It was from a law firm in Richmond, Whitmore and Associates. The letter was addressed to the occupant of 4782 Old Creek Road, and informed me that I was interfering with a legitimate construction project on HOA property. It demanded that I cease all interference, and warned that continued obstruction could result in legal action, including claims for damages and lost project costs. I immediately forwarded the letter to Uncle Robert, who contacted our family attorney, a woman named Patricia Morgan who had handled Grandpa's estate planning. Patricia was in her 60s, with steel gray hair and a no-nonsense demeanor that reminded me of my old contracts professor. We met at her office in downtown Charlottesville 2 days later. Patricia had spread out all the documents across her conference table: deeds, surveys, tax records, and the letter from the HOA's attorney. "This is fairly straightforward from our perspective," Patricia said, tapping the original deed. "Your grandfather has clear title to the entire 8 acres, including the section where they want to build. The survey confirms the boundaries. The tax records show continuous payment. There's no legitimate claim by the HOA. So why does the county have it listed as HOA land?" I asked. "That's where it gets interesting." I pulled the records from when Magnolia Ridge was developed. The developer, a company called Riverside Developments, submitted a plat map showing various common areas for the HOA. One of those areas was described with a meets and bounds description that's remarkably similar to your grandfather's back parcel. Similar how? The description references Old Creek Road and uses some of the same geographic markers. My theory is that someone at the developer's office copied part of the description from the county records, not realizing they were describing private property that wasn't part of their development. It's sloppy work, but it happens. Uncle Robert frowned, and the county just accepted it without verifying ownership. The county planning office processes hundreds of plats a year. They typically rely on the surveyor's certification and the developer's representations. If the paperwork looks proper, they file it. The problem is, once it's filed, it becomes part of the official record. So how do we fix it? I asked. Patricia sat back in her chair. We have a few options. The easiest would be if the HOA acknowledged their mistake and voluntarily corrected the records. But based on this letter, they're not inclined to do that. No, I spoke to their president. She's convinced they have the right to build. Then our second option is to file a quiet title action. That's a lawsuit asking the court to formally declare that your family owns the property and the HOA has no claim. It's not complicated legally since we have clear title, but it takes time and money. How much time and money? Uncle Robert asked. 6 months to a year, depending on the court schedule. As for cost, probably $15,000 to $20,000, maybe more if they fight it aggressively. I felt sick. And in the meantime, what's stopping them from just building anyway? We can get an injunction. That's a court order prohibiting them from doing any construction until the ownership issue is resolved. I can file for that next week. Do it, Uncle Robert said firmly. This is insane. They have no right to that land. Patricia nodded and made notes on her legal pad. I'll draft the complaint and the motion for preliminary injunction. James, I'll need you to sign an affidavit describing what happened when the construction crew showed up, and I'll need copies of the police report from that day. Over the next 2 weeks, I became intimately familiar with the legal system. Patricia filed our lawsuit in Charlottesville Circuit Court, naming the Magnolia Ridge HOA, Brenda Patterson in her capacity as president, and Riverside Developments as defendants. The complaint laid out our claim clearly. The Ellsworth family owned the property, the county records were wrong, and the defendants had no right to build on our land. The motion for preliminary injunction was scheduled for a hearing 3 weeks later. In the meantime, I tried to maintain some sense of normalcy, studying for the bar exam and taking care of the property. But the stress was constant. Every time a car drove past, I wondered if it was someone from the HOA coming to cause trouble. My concerns proved justified when, 2 days before the hearing, I came home from a grocery run to find Brenda Patterson standing in my driveway. She was exactly what I had imagined. A woman in her early 50s with shoulder-length blonde hair styled in perfect waves, wearing expensive-looking white capris and a coral blouse. She was standing next to a silver BMW, her arms crossed, watching the house with an expression of disdain. I parked my truck and got out slowly, leaving the groceries for the moment. "Can I help you?" She turned to me with a tight smile that didn't reach her eyes. "You must be James Ellsworth. I thought it was time we met face to face." "You're trespassing, Miss Patterson." "I'm going to have to ask you to leave," she laughed, a harsh sound. "Trespassing? That's rich, coming from someone who's squatting on HOA property. This is the Ellsworth family home. It's not HOA property, as you'll learn in court." "Oh, I've been in court plenty of times, young man." "Do you know how many liens I've filed against non-compliant homeowners? How many foreclosures I've overseen? I know exactly how the system works, and I can assure you we will win this case." "Is that a threat?" "It's a fact. we have documentation, we have county approval, we have permits. What do you have? Some old deed and a grandfather who probably didn't even understand property boundaries. The mention of my grandfather made anger flare hot in my chest. Don't talk about him. He understood perfectly well what he owned, and he maintained this property for over 70 years. Well, he's dead now, isn't he? And his heirs are too disorganized to even complete probate. The land was sitting here unused, so the county very reasonably designated it for community use. That's how property rights work. That's not how property rights work at all. You can't just claim someone's land because you want it. Brenda stepped closer, her eyes hard. Listen to me very carefully. Magnolia Ridge is a premier community. We have standards. We have amenities. Our property values are among the highest in the county. We don't need some trashy old estate bringing down the neighborhood. This property isn't in your neighborhood. It's not part of your development. It will be. One way or another, we're getting those tennis courts. You can make this easy or you can make it expensive. But the outcome won't change. Get off my property. Now. She held my gaze for a long moment, then smiled that cold smile again. See you in court, James. I watched her drive away, my fists clenched. Then I immediately called Patricia and told her about the encounter. She actually came to the house. Patricia sounded genuinely surprised. That's incredibly inappropriate, especially with active litigation. She was trying to intimidate me. Well, document everything. Write down exactly what she said while it's fresh in your mind. If she contacts you again, don't engage. Tell her all communication needs to go through me. The hearing for the preliminary injunction was held on a Wednesday morning in late June. The courthouse was an imposing brick building in downtown Charlottesville, with high ceilings and the kind of formal atmosphere that made me grateful for my legal education. Without it, I would have been completely lost. Patricia had prepared me thoroughly for what to expect. The hearing would be relatively informal, with both sides presenting their arguments and evidence to the judge. Our goal was to convince the judge that we had a strong likelihood of success on the merits, and that the HOA should be prohibited from building while the case proceeded. The HOA was represented by the attorney from Richmond, a man named Gregory Whitmore who wore an expensive suit and had the kind of polished confidence that came from years of courtroom experience. Brenda Patterson sat behind him at the defendant's table, her expression smug. Judge Margaret Torres took the bench promptly at 9. She was a Latina woman in her 40s, known for being sharp and efficient. Patricia had told me that Judge Torres had a reputation for not tolerating nonsense from either side. This is the matter of Ellsworth versus Magnolia Ridge Homeowners Association, the judge said, reviewing her notes. We're here on plaintiff's motion for preliminary injunction. Miss Morgan, you may proceed. Patricia stood and launched into her argument. She was brilliant, laying out the facts with clarity and precision. She presented the original deed, the survey, the tax records. She explained how the county records were wrong and how the HOA had sent construction crews onto private property without permission. She cited case law on trespass, property rights, and the requirements for an injunction. When it was Whitmore's turn, he was smooth but less convincing. He argued that the HOA had relied in good faith on the county records, that they had invested significant money in the tennis court project, and that preventing construction would harm the community. He presented the plat map from when Magnolia Ridge was developed, claiming it clearly showed the disputed parcel as HOA land. Patricia countered immediately, pointing out that the plat map's description was ambiguous and that the developer had no authority to designate property they didn't own. She also noted that the HOA had never tried to verify ownership before beginning construction. Judge Torres asked pointed questions of both sides, clearly trying to get to the heart of the matter. When Whitmore claimed that the Ellsworth family had abandoned the back parcel, the judge's eyebrows rose. Abandoned. The plaintiff has presented evidence of continuous tax payments and maintenance. Your Honor, the parcel in question is undeveloped land far from the main house. It appears the family wasn't using it for any purpose. Not developing land is not the same as abandoning it, Mr. Whitmore. Plenty of people own undeveloped parcels. After nearly 2 hours of argument, Judge Torres announced her decision. Based on the evidence presented, I find that the plaintiff has demonstrated a strong likelihood of success on the merits. The original deed and survey appear to clearly establish ownership of the disputed parcel. The county records may be in error, and that issue can be resolved in the full trial. However, allowing construction to proceed while ownership is disputed would cause irreparable harm to the plaintiff. The motion for preliminary injunction is granted. The defendants are hereby prohibited from conducting any construction activities on the parcel described in the complaint until this matter is resolved. I felt a wave of relief so powerful, I almost slumped in my chair. Patricia squeezed my shoulder, and I could see the satisfaction on her face. But when I glanced over at the defense table, Brenda Patterson was glaring at me with pure hatred. Whitmore was whispering something to her, probably telling her to keep calm, but she looked ready to explode. As we left the courtroom, I couldn't help but feel we had won a major victory. But Patricia was more cautious. "This is just round one," she reminded me. "We got the injunction, which is great, but now we have to prove our case in a full trial. And based on Whitmore's arguments, I think they're going to fight this hard." She was right. Over the next few months, the case consumed my life. I took the bar exam in July, feeling only partially prepared because so much of my energy had been focused on the property dispute. Patricia filed motions and conducted discovery, demanding documents from the HOA and Riverside developments. The defendants responded with their own discovery requests, demanding every piece of paper related to my grandfather's ownership of the property. In August, things escalated. Patricia received a counterclaim from the HOA, alleging that the Ellsworth family had known about the county records designating the parcel as HOA land and had failed to object for 5 years. They claimed this constituted a waiver of property rights and that they had detrimentally relied on the county records by planning and funding the tennis court project. They were seeking a court order granting them ownership of the parcel, plus damages for the cost of the delayed project. "They're trying to take ownership." I was incredulous. "How is that even possible?" "It's a long shot, but they're throwing everything at the wall to see what sticks," Patricia explained. Their argument is based on estoppel and lashes, basically legal doctrines that say if you sit on your rights for too long, you lose them. But it's weak. Your grandfather passed away 6 months ago, and the HOA only started this project 2 months ago. There's no way that's been enough time for any waiver or estoppel to apply. So why are they claiming it? To intimidate you, to make you think the case is more complicated than it is, and to run up your legal bills so you'll consider settling. I'm not settling. This is my family's land. Patricia smiled. "Good, because I think we're going to win, but you need to be prepared for this to get uglier before it gets better." She was right about that too. In September, I started receiving harassment from HOA members. It started with angry emails and phone calls, people I had never met telling me I was selfish and hurting the community by preventing the tennis courts from being built. Then, it escalated to online harassment, with people posting my phone number on social media and encouraging others to contact me. The worst incident happened in late September. I came home one evening to find that someone had spray painted "selfish" and "thief" across the front of Grandpa's house. They had also slashed the tires on my truck. I called the police immediately. The same Sergeant Williams who had responded to the construction dispute came out to take the report. He walked around the property, photographing the damage and taking notes. "You have any idea who did this?" he asked. "I've been getting harassed by members of the Magnolia Ridge HOA. We're in a legal dispute about property boundaries." Williams nodded slowly. "I remember. The tennis courts. You think someone from the HOA did this?" "I can't prove it, but the timing is suspicious. We have a trial coming up in a few weeks. I'll include that in the report." "Do you have security cameras?" "No, but I'm going to install some." After he left, I sat on the porch steps, looking at the spray paint and feeling a mix of anger and exhaustion. This had started as a simple property dispute, but it had turned into something much darker. These people were willing to commit crimes to get what they wanted. I called Patricia the next morning and told her about the vandalism. She was furious and immediately filed a motion with the court, informing Judge Torres about the harassment and requesting sanctions against the HOA if any further incidents occurred. She also suggested I consider filing a police report and possibly seeking a restraining order against Brenda Patterson specifically. "We don't have proof she was involved," I pointed out. "No, but she's the president of the HOA, and she's responsible for the culture she creates. If her members think it's okay to harass you, that reflects on her leadership." The trial was scheduled for mid-October. As the date approached, my stress levels went through the roof. Patricia had prepared meticulously, organizing binders full of evidence and lining up expert witnesses, including the surveyor who had done the 2023 survey of Grandpa's property. But I couldn't shake the feeling that something was going to go wrong. The night before the trial, I barely slept. I kept running through everything in my mind, thinking about all the ways the HOA might try to twist the facts or confuse the issue. When morning finally came, I dressed in my best suit, the one I had bought for law school interviews, and drove to the courthouse. The trial was held in the same courtroom where we had won the injunction. Judge Torres presided again, which Patricia said was a good sign. The jury box was empty since this was a bench trial, meaning the judge would decide the facts as well as the law. Patricia's opening statement was clear and compelling. She explained the history of the property, showed the deed from 1947, and walked through how the error in the county records had occurred. She emphasized that this was a simple case of property ownership, and that all the evidence supported the Ellsworth family's claim. Whitmore's opening was more aggressive. He portrayed my grandfather as an absentee landowner who had neglected the back parcel for decades. He claimed the HOA had a good faith belief in their ownership based on county records, and that they had invested over $200,000 in planning and permitting for the tennis courts. He argued that preventing the project would harm hundreds of families in the Magnolia Ridge community who were counting on the recreational facility. The first witness Patricia called was Uncle Robert. He testified about the family history with the property, explaining how Grandpa had bought the land after returning from World War II and had lived there for over 70 years. He described how Grandpa had walked the entire property regularly, maintaining the fences and clearing brush, including the back parcel where the HOA wanted to build. Whitmore cross-examined aggressively, trying to suggest that the back parcel was so far from the house that Grandpa couldn't have been actively using it. Uncle Robert held firm, pointing out that just because land is undeveloped doesn't mean it's not owned and cared for. Next was the surveyor, a professional named Thomas Reed who had done the 2023 survey. He brought large maps and diagrams, showing the exact boundaries of the property and how they had been determined. He explained the methodology of surveying, the use of historical markers and deed descriptions, and confirmed that the back parcel was definitely within the Ellsworth property lines. Whitmore tried to poke holes in the survey, suggesting that the old deed descriptions were ambiguous and that modern GPS technology might show different boundaries. Reed calmly explained that while GPS was useful, professional surveying used multiple methods to ensure accuracy, and he was confident in his work. The third day of trial was when things got really interesting. Patricia called a witness I hadn't expected, a former employee of Riverside Developments named Michael Chen. Chen had worked in the planning department when Magnolia Ridge was being developed, and he had explosive testimony. Can you explain your role in creating the plat map for Magnolia Ridge? Patricia asked. Chen, a nervous-looking man in his 30s, nodded. I was responsible for compiling the property descriptions and creating the maps that we submitted to the county. The project manager gave me a list of parcels that were supposed to be designated as common areas for the HOA. And how did you create the descriptions for those parcels? I used the county's property database. I would look up the parcel numbers and copy the meets and bounds descriptions from the existing records. Did you verify that Riverside Developments actually owned those parcels before designating them as HOA land? Chen hesitated. I assumed that had been done by someone else. My job was just to compile the information. So you didn't verify ownership? No. Patricia pulled out a copy of the plat map and pointed to the disputed parcel. This description here, which matches the back section of the Ellsworth property, did you create this description? Yes. I pulled it from the county database based on a parcel number the project manager gave me. Is it possible the project manager gave you the wrong parcel number? Objection, speculation, Whitmore said quickly. I'll allow it, Judge Torres said. The witness can answer based on his experience. Chen cleared his throat. Yes, it's possible. We were working on a tight deadline, and there were hundreds of parcels involved in the project. Mistakes could happen. Whitmore's cross-examination was brutal, trying to paint Chen as incompetent and his testimony as unreliable. But the damage was done. Chen's testimony showed that the plat map had been created carelessly, without proper verification of ownership. The HOA's witnesses were less impressive. Brenda Patterson took the stand and immediately made a bad impression. She was defensive and condescending, repeatedly insisting that the HOA had done everything properly, and that it was the Ellsworth family's fault for not monitoring the county records. Miss Patterson, when did you first learn that the Ellsworth family was claiming ownership of the disputed parcel? Patricia asked during cross-examination, when that young man called me and rudely demanded that we stop our project. That would be James Ellsworth. Yes. And what did you do after receiving that call? I consulted with our attorney and reviewed our documentation. Everything showed that we owned the land. Did you look at the actual deed records for the Ellsworth property? Brenda's jaw tightened. That wasn't necessary. We had county approval. So you never actually verified whether the county records were correct. The county is responsible for maintaining accurate records. We relied on them in good faith. Even after being informed that those records might be wrong, we had no reason to believe they were wrong. Patricia paused, letting that answer hang in the air. Miss Patterson, you visited the Ellsworth property in June, did you not? I stopped by to discuss the situation with Mr. Ellsworth. Yes. What exactly did you say to him during that visit? Brenda looked uncomfortable. I don't recall the exact words. Let me refresh your memory. Did you tell Mr. Ellsworth that his grandfather probably didn't understand property boundaries? I may have said something like that. And did you tell him that you would get the tennis courts one way or another? I was expressing confidence in our legal position. Did you also call the Ellsworth property trashy? Whitmore stood up. Objection, relevance. Your Honor, this goes to the defendant's attitude and credibility, Patricia said. I'll allow it. Miss Patterson, please answer the question. Brenda's face was red. I may have expressed concern about property maintenance by calling it trashy. I don't remember using that exact word. But you don't deny it. I don't recall. Patricia moved on, but the point was made. Brenda Patterson came across as arrogant and unreasonable. Exactly the kind of person who would push forward with a project even after being told it was wrong. The HOA also called an expert witness, a land use attorney who testified about how county records are maintained and how HOAs typically handle common areas. But his testimony was mostly generic and didn't address the specific facts of our case. Closing arguments took place on the fourth day of trial. Patricia was masterful, tying together all the evidence and making it clear that the Ellsworth family had owned the property continuously for decades, that the county records were wrong due to a clerical error, and that the HOA had proceeded recklessly without verifying ownership. Whitmore's closing focused on the HOA's good faith reliance on county records and the investment they had made in the project. He tried to paint the Ellsworth family as obstructionist and selfish, but it rang hollow after all the evidence we had presented. Judge Torres took the case under advisement, saying she would issue a written opinion within 2 weeks. Those 2 weeks felt like 2 years. I tried to stay busy, but I couldn't focus on anything else. Everything hinged on this decision. The opinion arrived on a Friday afternoon in early November. Patricia called me immediately, her voice excited. We won, complete victory. I felt like I couldn't breathe. What did she say? I'm reading it now. Hold on. I could hear papers rustling. Okay, here's the key part. The court finds that the plaintiff has established by clear and convincing evidence that the Ellsworth family has held continuous, uninterrupted ownership of the disputed parcel since 1947. The county records designating said parcel as HOA common area are in error and do not override the established chain of title. The defendant HOA has no colorable claim to the property and was trespassing when they attempted to initiate construction. The court hereby orders that the county records be corrected to reflect the Ellsworth family's ownership and that the defendants are permanently enjoined from any further attempts to build on or otherwise use the disputed parcel. That's it. We won. That's not all. Judge Torres also found that the HOA acted in bad faith by proceeding with construction after being informed of the ownership dispute and by failing to conduct proper due diligence before beginning the project. She's awarding us attorneys' fees and costs. How much? She hasn't set the amount yet. We'll have to file a motion documenting our fees. But James, this is a complete win. Everything you wanted. I sat down, feeling dizzy with relief. It was over. After 5 months of stress, harassment, and legal battles, it was finally over. But the story didn't end there. A week after the judgment, Patricia received a notice that the HOA was appealing. Whitmore filed papers with the Virginia Court of Appeals, arguing that Judge Torres had made errors in her analysis and that the case should be overturned. Can they do that? I asked Patricia when she called to tell me. They can appeal, yes, but I don't think they'll win. Judge Torres's opinion is thorough and well-reasoned. There's no obvious error for the appellate court to overturn. How long will an appeal take? 6 months to a year, maybe longer. But the injunction stays in place during the appeal, so they still can't build. I groaned. This is never going to end. It will, I promise. They're just throwing one last Hail Mary. Try not to worry about it. That was easier said than done. The harassment had stopped after the trial, but knowing that the case was still pending made me anxious. I had passed the bar exam and gotten my results in late October, which was a bright spot. I was officially a licensed attorney now. But instead of looking for jobs or starting my career, I was stuck in limbo, waiting for an appellate court to decide the fate of my grandfather's property. The holidays came and went. I spent Christmas with my family, trying to focus on celebration rather than litigation. Uncle Robert assured me that whatever happened, we would see this through. The property was too important to our family to give up. In January, I made a decision. I couldn't keep living at the property full-time, waiting for the appeal to resolve. I needed to start my life. I got a job at a small law firm in Richmond, doing general civil litigation. It wasn't glamorous, but it was experience. I drove back to Charlottesville every weekend to check on the house and make sure everything was okay. The months dragged by. Patricia filed our response to the appeal, a thorough brief explaining why Judge Torres had been correct on all points. We waited for the Court of Appeals to schedule oral argument. Finally, in May, nearly a year after the construction crew had first appeared on the property, we got notice that oral argument would be heard in June. Patricia prepared extensively, anticipating every possible question the judges might ask. I took the day off work to attend the argument. The Court of Appeals sat in Richmond, in a building even more imposing than the Charlottesville courthouse. The courtroom was formal and intimidating, with 3 judges sitting at an elevated bench. Patricia argued first, calmly explaining why the trial court had been correct. The judges asked some questions, mostly seeking clarification on technical points, but they didn't seem hostile. Then Whitmore argued for the HOA. He tried to make the case that the trial court had given too much weight to the historical deed and not enough weight to the county records. He argued that property owners have a responsibility to monitor county records and object to errors, and that the Ellsworth family had failed to do so. One of the judges, an older woman named Justice Harrison, interrupted him. "Mr. Whitmore, are you seriously arguing that a family loses property rights because they didn't check county records to make sure there were no clerical errors?" "Not loses, Your Honor, but they should bear some responsibility for ownership is established by deed, not by county administrative records," Justice Harrison said sharply. "Those records are maintained for tax and planning purposes, but they don't override actual title." "Isn't that basic property law?" Whitmore floundered for a moment. "Yes, Your Honor, but when someone relies in good faith on those records, the record shows your client was informed of the error before beginning construction and chose to proceed anyway. That's not good faith, counsel." I saw Patricia trying not to smile. The argument lasted less than an hour. As we left the courthouse, Patricia was cautiously optimistic. "I think we're in good shape." Justice Harrison seemed pretty skeptical of their arguments. "When will we know? Could be a few weeks, could be a few months." Appellate courts move slowly. It ended up being 6 weeks. The opinion came down in late July, and it was everything we could have hoped for. The Court of Appeals affirmed Judge Torres's decision in its entirety, agreeing that the Ellsworth family had clear title and that the HOA had no claim to the property. The court also noted that the HOA's decision to appeal appeared to be an attempt to harass the plaintiffs, and suggested that additional sanctions might be appropriate if they continued to litigate. "It's over," Patricia told me over the phone. "They can try to appeal to the Virginia Supreme Court, but that's discretionary. The court doesn't have to hear it, and based on this opinion, I don't think they'll bother. She was right. The HOA didn't appeal further. 2 weeks later, I received a check from Whitmore's firm, covering our attorney's fees and costs as ordered by Judge Torres. The amount was substantial, nearly $30,000, but there was one final twist. In August, I got a call from Sergeant Williams with the Charlottesville Police Department. "Mr. Ellsworth, I wanted to let you know that we've made an arrest in connection with the vandalism at your property last year." "Really? Who was it?" "A woman named Susan Mitchell. She's a resident of Magnolia Ridge. She was bragging about it at a neighborhood party and someone reported her to us." "Did she say why she did it?" "According to the report, she was angry about the tennis court project being canceled. She blamed you." "We're charging her with vandalism and trespassing." "What about Brenda Patterson? Was she involved?" "We haven't found evidence of that, but we're still investigating. Mitchell mentioned that Patterson made comments at HOA meetings about you being an enemy of the community. We're looking into whether that constitutes incitement." The investigation ended up revealing even more. A detective contacted me in September, asking if I would be willing to testify before a grand jury. Apparently, the investigation into Susan Mitchell had uncovered evidence that Brenda Patterson had been encouraging HOA members to harass me. There were emails and text messages from last fall, with Brenda suggesting that if I was made uncomfortable enough, I might drop the lawsuit. "Is that illegal?" I asked the detective. "Potentially. It could be conspiracy to commit harassment or intimidation of a witness. The prosecutor is reviewing the evidence now." In October, more than a year and a half after this whole nightmare had started, Brenda Patterson was arrested and charged with conspiracy to commit vandalism and witness intimidation. The news made local headlines, and the story of the HOA president who tried to steal land and then harassed the rightful owner became a minor sensation. The Magnolia Ridge HOA board voted to remove Brenda from her position while the charges were pending. Several board members resigned in protest, claiming they had been unaware of Brenda's actions. The whole organization was in chaos. Susan Mitchell pleaded guilty to vandalism charges and was sentenced to community service and restitution for the damage to the house and my truck. Brenda Patterson's case took longer. She initially pleaded not guilty, but as the evidence mounted, her attorney negotiated a plea deal. She ended up pleading guilty to witness intimidation and was sentenced to 6 months in jail, suspended to probation, and ordered to pay a fine. The terms of her probation included a condition that she have no contact with me or my family, and that she resign from any position of authority in the HOA. By the time everything was finally resolved, it was early 2027, nearly 2 years after that Tuesday morning when I first heard construction equipment on Grandpa's property. The legal battle had consumed a huge chunk of my life, cost tens of thousands of dollars even with the fee award, and caused enormous stress. But we had won. The property remained in the family, the county records were corrected, and the people who had tried to take what wasn't theirs had faced consequences. I eventually moved back to Charlottesville permanently, taking a job with a different law firm and living in Grandpa's house. My mother and her siblings decided not to sell the property after all. It meant too much to the family, and fighting for it had reminded us all of its value. I had the front of the house repainted, installed a security system, and put up a new sign at the end of the driveway. Ellsworth Family Estate Private Property, No Trespassing. I made sure it was visible from the road. Every now and then, I would walk out to the back parcel, the section where the HOA had wanted to build their tennis courts. The grass grew tall there and wildflowers bloomed in the spring. It was beautiful in its natural state, and I was glad we had fought to keep it. I also learned an important lesson about HOAs, property rights, and the importance of standing up for what's right. When Brenda Patterson had come to the house that day, trying to intimidate me, she had been confident that she would win. She had the weight of an organization behind her, expensive lawyers, and the belief that might makes right. But property rights are fundamental to our legal system. You can't just take what belongs to someone else, no matter how many meetings you hold or how many permits you file. And when someone tries, there are mechanisms to fight back. The whole experience also made me a better lawyer. I had seen firsthand how legal disputes affect people's lives, how important it is to have good representation, and how the system can work when people have the courage to stand up for themselves. I heard through the grapevine that Magnolia Ridge eventually built their tennis courts on a different piece of land, a parcel they actually owned within the development. The project cost more because they had to reconfigure their plans, and it was completed 2 years later than originally scheduled. Some homeowners were unhappy with the delay and the increased fees they had to pay, and there was a wave of turnover on the HOA board. Brenda Patterson moved away from Charlottesville after her probation ended. I didn't know where she went, and I didn't care. As far as I was concerned, she had gotten what she deserved. Susan Mitchell, who had vandalized the house, actually reached out to me after completing her community service. She sent a letter apologizing for her actions and explaining that she had been caught up in the rhetoric at HOA meetings. She said she had learned a hard lesson about thinking for herself rather than following the crowd. I appreciated the apology, though I never responded. As time went on, the whole incident became a story I would tell at parties or family gatherings. Did I ever tell you about the time an HOA tried to steal Grandpa's land? It seemed almost surreal in retrospect, like something that couldn't have really happened. But it did, and I had the court documents to prove it. The property itself became a refuge for me. After spending long days at the law firm, working on other people's legal problems, I would come home to those 8 acres and feel a sense of peace. I understood why Grandpa had loved this place so much. It was a connection to something permanent and real, a piece of earth that belonged to our family and always would. I eventually got married to a woman named Alina Jenkins, who I met through work. When I told her the story of the property dispute, she was amazed and insisted on reading all the court opinions. She loved the property as much as I did, and we talked about raising kids there someday. My mother and her siblings officially completed probate in early 2027, with the property being divided among the heirs. I bought out their shares, borrowing money to do so, because I wanted to be the one to keep the place in the family. They were happy to let me have it, knowing how much I had fought for it. The back parcel, the section that had caused so much trouble, remained undeveloped. I thought about building something there sometimes, maybe a workshop or a guest house, but I never did. I liked it wild and natural, just as Grandpa had kept it. Years later, when I became a partner at my law firm, specializing in property and real estate law, I would sometimes represent clients in disputes with HOAs. I had a reputation for being tough in these cases, and more than one opposing counsel complained that I was unreasonably aggressive. But I knew from personal experience what HOAs could do when they believed they were above the law, and I wasn't about to let that happen to my clients. I also became involved in efforts to reform HOA laws in Virginia. I worked with state legislators on bills to increase transparency and accountability, to protect homeowners from abusive practices, and to create better mechanisms for resolving disputes. Some of the bills passed, others didn't, but I felt like I was making a difference. The Ellsworth property became something of a local landmark. People in Charlottesville knew the story of the HOA that tried to steal land and the young lawyer who fought back. When I gave talks at the law school about property rights, I would use my own case as an example, walking students through the legal strategy and the lessons learned. Looking back on everything, I realized that what had started as a nightmare had actually changed my life for the better. It had given me purpose, taught me about the law in a way that no classroom ever could, and connected me more deeply to my family's history. It had also shown me the importance of standing up to bullies, whether they wear business suits or preside over HOA meetings. The tennis courts that were never built became a symbol to me. They represented everything that's wrong with the HOA system when it's abused: the arrogance, the overreach, the assumption that rules and regulations trump individual rights. But they also represented the fact that the system can be beaten, that justice can prevail, and that ordinary people can fight back against institutional power. Grandpa's property remained in the family, just as it should. The 8 acres of rolling Virginia hills, the old colonial house with its white siding and black shutters, the gardens and the woods and that controversial back parcel, all of it stayed with us. And every time I walked those grounds, I thought of Grandpa and the legacy he had left us, a legacy that was about so much more than just land. It was about standing your ground, about knowing what matters, about fighting for what's right even when it's hard. Those were lessons worth learning, and they came at a price. But in the end, looking at those 8 beautiful acres that almost slipped away, I knew the price had been worth paying. The story of the HOA that tried to build tennis courts on the Ellsworth property became a cautionary tale in Central Virginia. Real estate attorneys cited it in briefs, law professors used it in classes, and homeowners dealing with their own HOA disputes would reach out to me for advice. I always made time to help them, remembering how isolated and overwhelmed I had felt in those early days. As years passed, and I built my career and my life on that property, I sometimes thought about that Tuesday morning when everything started. The sound of heavy machinery, the confusion and anger, the realization that someone was trying to take what belonged to my family. It had been one of the worst days of my life in that moment, but it had also been the beginning of something important. I learned that property rights matter, that the law can be a powerful tool for justice, and that sometimes the fight is worth it no matter how hard it gets. Those lessons shaped everything that came after, both in my career and in my life. And every time I walked out to that back parcel, where the grass grew tall and the wildflowers bloomed and no tennis courts would ever be built, I felt a deep sense of satisfaction. This was my family's land. We had fought for it, we had won, and it would stay with us for generations to come. That was the real victory, not just the court judgment or the attorney's fees or seeing Brenda Patterson face consequences for her actions. The real victory was preserving something precious, something that connected us to the past and would carry us into the future. In a world where so much feels temporary and uncertain, that permanence mattered. The Ellsworth estate stood as proof that you can fight City Hall, or in this case, an HOA. You can stand up to bullies with expensive lawyers and institutional power. You can win if you have the facts on your side and the courage to see it through. Those were lessons I would carry with me for the rest of my life, lessons that started with the simple act of refusing to let strangers build tennis courts on my grandfather's land.